Good morning, Ms. Clerk. Are we on the record?
Yes, we are.
This is case D20-609-898-F, Brandon Adams versus Yvette Adams. Do we have Brandon present?
Yes.
Okay, and do we have Yvette present?
Present.
Okay, we're here because Yvette has filed a motion to object to Brandon's registration of the decree of divorce from New Jersey, which contains child custody orders here in the state of Nevada. And Brandon has filed a motion for and Yvette has also filed a motion for an order to show cause. There's been no opposition filed by Mr. Adams, although he's filed a plethora of documents, most of which do not have proof of service to Yvette. What I have before the court is the objection to Dad's petition for registration, but I also have a request for the court to enforce the New Jersey order. I can't enforce the New Jersey order unless the case is registered here. Registration only means that it gives the court the ability to enforce the order. Registration doesn't mean the court has jurisdiction to modify the order. It just means that the court has jurisdiction to recognize it and enforce it. Okay, do you understand the difference?
I do now.
Okay, so with that said, do you, the court's denying Mom's objection to Dad's petition for registration because you can register your decree anywhere, your custody orders anywhere. The objection is to the authenticity of the order. So I guess, let me ask you, is the New Jersey custody orders, is that the decree of divorce? Is that the most recent custody order?
Yes, it is.
Okay, that would really be your only reason for objecting, is that that's not the correct order, okay? That there's a newer order in place. So the request, Mom's motion to, or objection to Dad's petition for registration is denied. Mr. Adams, you need to submit the order, or one of you, somebody's got to actually submit the order of registration to the state of Nevada, because without that, I don't have an order to enforce. So there's one more step that needs to be, it's been interrupted because of the objection. But go ahead and submit that order, and that way the court has something to enforce. So right now it's premature for the court to enforce the order, Mom's request to enforce. Dad's filed a great many documents, but again, there isn't a proper motion before the court. There isn't proof of service. There's not a notice of hearing. So due process hasn't been complied with. And Nevada, under the circumstances that I see, if Mom and the children were allowed to move to Georgia, and the children have been residing in Georgia, and that's apparent from even the documents filed by Dad, Georgia would have child custody subject matter jurisdiction, and under the UCCJEA, that's a Uniform Child Custody Jurisdiction and Enforcement Act, Nevada lacks child custody subject matter jurisdiction to modify. Can enforce, but can't modify, okay? That belongs to wherever the children's home state is, and that would be Georgia. So, Mr. Adams, if you want to modify that order, you need to take your documents to Georgia. You need to domesticate. What you've done here is register the orders here. You have to register the orders in Georgia, okay, and move to modify those in Georgia, because this court doesn't have jurisdiction to modify the orders.
Well,
okay.
According to me doing research with the Nevada Uniform Child Custody Jurisdiction Enforcement Act under 125A.315, it does show that Nevada, with me filing that they do have the ability to take jurisdiction, especially if there's been any, complaints against physical abuse to a child or neglect to a child.
Under 315?
Mm-hmm. 225A.
There is a Sir, there's a provision for emergency jurisdiction if the children are here, present in the state.
Well,
But you haven't
two of
filed.
them are.
Judge,
Hold on.
the defendant
Yes.
just left the call. Oh, she joined again. Okay.
Okay. Ma'am, are you present? Yvette? Yvette, are you present? Can you hear us?
I had good connection. I'm back. I had to switch my connection. I apologize.
Okay. Sir, you haven't filed a proper motion for that. That's what you're asking for. You haven't filed, there's no motion. You've just filed a plethora of documents, but you filed no motion at all. You haven't filed an opposition. Mom's motion asking to enforce the orders. You've just filed a whole lot of documents, most of which I don't think any of which you've served on Mom.
Yes,
So
I did serve her, and I got proof of service when I first sent the registration. And you should see the stamp that she did get served through.
Okay, but there's nothing else. You've got a whole lot of documents that you've filed, but you don't have, they're not properly before the court. You filed an answer to the counterclaim, which is not an appropriate document to file. You have a FMC request and order, which the court actually signed, but the clerk, Ms. Clerk, can you please vacate that order? That was entered August 24th, 2020, because the court Nevada doesn't have child custody subject matter jurisdiction, so can't send the parties to mediation for modifying their orders. There's a TPO application you filed. It's not set for a hearing, and then there's a bunch of documents. There's physician's letter, defendant's affidavits, there's a dermatology letter, there's a whole bunch of stuff, but there is stuff is kind of concerning because it sounds like dad and possibly mom are inappropriately involving the children in their adult dispute. That would be a concern of this court. But again, this court doesn't have child custody subject matter jurisdiction to modify. If there's emergency jurisdiction, that hasn't been brought to the court's attention in a manner that's properly before the court today. All right, so the mom's order to enforce would be granted upon submission of the actual order. I still need the order of registration. I don't have that. Right now, technically, I have nothing to enforce. Okay, so one of the two of you needs to submit that order of registration, and then after that, mom's motion for to enforce the order is granted. I don't have an opposition to that, and I don't have anything else filed by dad properly before the court. Mr. Adams, did you have something else to say?
I do. We have a mediation that was signed by you on August the 24th, and we have a court hearing, and mediation usually takes place before a court hearing.
Yes, sir.
It was signed on.
I've just vacated that because this court lacks child custody subject matter jurisdiction. We routinely, and I'm sorry for the confusion, we routinely grant those because it's good for people to go to mediation. But now that I've learned that this court doesn't have child custody subject matter jurisdiction, I have jurisdiction to send you to mediation. Okay?
My other question is on the temporary protection order. You say it was not
order. There's a application for one, but it's not set for hearing.
Right, I understand that.
Okay.
But it was submitted. I'm sorry.
It wasn't. It's not set for hearing, and it's not mailed to mom, so it's not properly before the court today. We have an office. We have a temporary protective order process that's through the temporary protection order. We have special hearing masters for TPOs. You can bring them here, but it's not properly before this court because there isn't a hearing that's set, nor is there proof of service. Okay, I can't go forward on something when there isn't due process. All right.
So with the modification, I mean the mediation that showed that the court automatically submitted because there is proof of service on there from the court. I know you say that you denied it.
I don't have no, right now I've just vacated. I agree, I signed
Vacated it, right.
Okay, but I vacated it. This court doesn't have child custody subject matter jurisdiction to modify.
Okay. And under exclusive continuing at a Uniform Child Custody Jurisdiction Act under 125A315, because Georgia does not have jurisdiction for the mom, because the court case was opened in New Jersey, she moved the children to Georgia, and 2 of the children are here in Nevada presently. And there are 2.
Under the UCCJEA, once everybody has left the original jurisdiction, New Jersey lost exclusive jurisdiction to modify custody. New Jersey may still have continuing jurisdiction, but it lost exclusive jurisdiction. The court will, New Jersey has continuing jurisdiction to determine, where this matter ought to be, and this matter next under the rules would go wherever the children have resided continuously for the last 6 months. Okay, and that would be Georgia, right?
Well, Georgia does not actually have jurisdiction because, yes, they have. Go ahead.
Why don't they?
Because the original court case was ordered in New Jersey, and once she moved out of New Jersey, there was never an order entered into the state of Georgia. So New Jersey lost.
And that's what I'm explaining to you, is that New Jersey lost exclusive jurisdiction because nobody lives there anymore. New Jersey still has continuing jurisdiction should somebody bring a matter there, but it's quite likely that once New Jersey figures out that the children, no one lives there anymore, they kind of don't have an interest anymore, and the children are residing in Georgia, and Georgia has become the children's home state, that's the appropriate place to modify. But someone needs to register the order in Georgia.
So with all the complaints, which is another concern of mine, with the children constantly talking about they have physical abuse by the mother spitting in their face, mother slapping them 5 times, their brother punching them, and go ahead.
You don't have any of that properly before this court. Most of this you haven't served on mom, so it's not fair to go forward, okay? Again, we have a process to have a temporary protective order. There's a temporary protective order process. You can go to that particular court. You have submitted an application for a TPO, but you haven't followed it up with any kind of a temporary order. You haven't set it for hearing.
But the original custody.
Procedurally, there isn't anything that the court's going to do today because you don't have your matters procedurally properly before the court.
Well, in the original order, that where she was properly served, and the court does have proof of service and is stamped by the court, and in the original paperwork with the affidavits that the court did stamp, it shows that the original order showed that there was concerns brought to the court with her being properly served, that the court did stamp that there was
that doesn't
concern.
give this court jurisdiction to do what it is you're asking the court to do for 2 reasons. One, this court lacks child custody subject matter jurisdiction. Even if this court took emergency jurisdiction, which is not properly before the court because Dad has not filed anything that gives us a hearing date, okay? This court would only accept emergency jurisdiction if it determined there was an emergency, and that would only last long enough for someone to open the proper case in Georgia. Okay, it's not permanent. It's only
Right.
temporary.
I understand it's not permanent, but my main concern is you stated a few times that she was not properly served.
Sir, you haven't served your documents here, okay?
Right, but there's a proof of service from the United States Post Office with registered mail stamped by the court in the original order that shows that there was concern.
Sir, which court?
Huh? Nevada.
Which court?
Nevada.
Where? We don't send registered mail to people. We don't send registered mail. We don't send registered mail to people.
No, I'm not saying you. You said I did not properly serve her, which in the family court documents, properly being served is certified mail with the return
Okay.
Go ahead.
I indicated that you served the petition for registration, but I don't have proof of service of the plethora of other documents that you filed in this case. Okay?
But I'm confused how the modification order got vacated when it was signed, and it shows from the court that she was properly served from the court, but then the modification should have taken place because a modification always goes before a court
Talking
date.
about mediation? If you're talking about mediation,
I'm saying mediation. And it was signed off on, and it was also showing that she was properly served.
Okay,
But yet,
please listen carefully. Please listen carefully, because I've already explained this twice now. I am vacating the order for mediation because this court does not have child custody subject matter jurisdiction to modify your orders. Georgia does, not this court. Okay? So it's improper for this court to send you to mediation. At the time the court sent you to mediation, I didn't know these facts. Okay? That's just because somebody submitted an order for mediation. I'm vacating.
Okay, but you say Georgia has jurisdiction, and I'm very confused on how Georgia has jurisdiction where you say Nevada does not have jurisdiction, but Georgia has
children
jurisdiction.
resided here for 6 months? Have the children resided here for 6 months? Have
Longer
the children
than, yes.
resided here, sir, in the state of Nevada for 6 months? No?
Right.
Okay. So we don't have home state jurisdiction. That's where it goes. So it's okay. Please mute your microphone, ma'am, because it's causing feedback.
Oh, jeez.
All right, sir. So right now, the only court that has jurisdiction to modify is New Jersey. That's only kind of continuing jurisdiction until a case gets moved to Georgia. Somebody has to register the New Jersey, just what you did here in Nevada. You registered the New Jersey case in Nevada. Somebody needs to register the New Jersey case in Georgia or Georgia.
But I'm also understanding that you're saying that it can be registered here in Nevada, and the only reason why it wasn't was because you said that the documents that I served she wasn't properly served. But
No,
there
that's
was
not what I said.
documents like her
Sir.
opposition to my order. I never got served from her, and I'm supposed to get served by the other party as well. And I did not get any documents for her motion. There's nothing showing that she properly served me, and I do not have none of that.
Your petition filed, you served it. Your petition only registers the order in Nevada under the full faith and credit clause of the United States Constitution. This state is required to recognize proper orders of other states. Registration alone does not give this court jurisdiction to modify, only to recognize and enforce, not
Right,
to modify.
I understand that, but if I'm
why do you
supposed
keep
to
asking
properly,
me the same question about why
no,
I'm
this
not
is a
modifying?
this is a different question, because you said that I didn't properly serve her. She didn't properly serve me either, because there's nothing on record showing that she properly served me as well.
All right, ma'am, have you served him with your objection, your motion?
What I did was I responded to the
Yes or no?
motion. So
Yes
no,
or no?
I just responded.
No, you didn't.
No, I just.
Okay. All right, we're going to continue this. You need to file your let me see. You know what? We're not going to continue this. If you haven't served your documents, then there's no due process. Okay? He needs to be able to. He's got a good point there, and his point is that he's got to get notice of your objection, and he has to get notice of your motion. Okay? Let's see, I thought those were served. We're not. So this is off calendar. This court is not going to do anything until the case is registered. From the discussion today, Mom is acknowledging to the court that the New Jersey order is the last order filed, so there would be no basis for an objection to registration. Somebody needs to submit order for registration to this court. And ma'am, your motion to enforce, not only is it premature, because I don't have a motion, I don't have an order submitted, but of registration, but if you didn't mail a copy to Dad, then it's inappropriate for this court to move. Okay? Because he needs to get served.
Is that for all of the documents that I filed? I thought I was responding to the court. Is that for all of the documents that were filed?
Yes. Whenever either of you files anything with the court, you need to send a copy to the other side. Okay? Court. Otherwise, it's just ex parte information. Court can't consider just random information that you file with the court, because the other side needs to have notice and an opportunity to be heard. That's due process. It's a fundamental concept of justice and fairness. Notice and an opportunity to be heard. If you don't give the other side copies of your documents, then the court won't know. The other side won't have due process. Okay? All right. So since Mom's motion wasn't noticed to Dad, then that is vacated. If you want to, you'll have to refile it, serve it. Okay? So that we have a hearing date and whatnot. If you want the again, you had filed, one of your motions was to object to. So do you still object to the entry of the order here, the registration?
Now that you've clarified that the filing of the petition to register does not give the state jurisdiction, then I don't have an objection. I didn't before. I thought it was because it was giving the state full jurisdiction, and that was my objection.
No, that's not what it does. It's only just to... Okay, so are you withdrawing that motion then?
I can withdraw the opposition, the objection to the registration.
Okay. All right, so either one of you then can submit an order of registration to this court, which would be necessary before the court could hear the motion to enforce, and the motion to enforce also must be served on Dad. Okay? You need to mail him a copy. Last night as evidence. Okay?
Can do that. And I have one question. I was trying to wait till the other discussion was complete. The request for the emergency pickup order, is that also not able to be addressed today?
Well, because I want to hear what's going on. I usually don't grant those unless I know what's going on. I don't really know what's going on.
Is that not able to be discussed today?
No, I'm not going to hear it today. Okay? You've already submitted it for the court ex parte. The court's not inclined to grant it ex parte. The court wants to hear what's going on, but I can't hear what's going on, sir. You haven't, there's so many of these documents you haven't mailed to Mom. So procedurally, please get some assistance, both of you, right? Because It's difficult for the court to do much when the matter's not properly before the court. Because there's all these issues of due process. I've got to make sure everybody's got a copy of the documents you want the court to rely on in making rulings. Without the order registering, I can't issue the pickup order. The court doesn't have a basis to grant the pickup order in any event. Even if the court were inclined to listen to it today, I don't have a basis because I don't have an order registering the case. So I have no order to issue a pickup order about. You'd started off with objecting to the registration, so we're not going to be signing pickup orders on a document that you're objecting for it to be registered here, right? So you can see how the procedural things kind of can tangle things up. Both of you, please get some assistance. Some of the stuff is complicated. The jurisdictional issues can be really complicated and confusing. Okay, so please seek some assistance. I'm taking the matter off calendar then. Okay, thank you.
Thank you.